Now I'm in practice with my daughter. Lewin and Lewin is the name of the firm, surprisingly. I was then in practice with a law firm that was a litigation boutique called Miller, Cassidy, LaRocca, and Lewin. The first three names, not Jewish. Miller was not a Jewish name. Jack Miller was not Jewish. Cassidy, LaRocca, and Lewin. People said it was a dream New York City mayoralty ticket. But people would say to me, Lewin, you argue cases in the Supreme Court, you teach in leading law schools, why are you the last name on that law firm? And I would respond, you don't understand. My clients read from right to left. So the other partners in my firm were very patient, and they allowed me to represent various Jewish interests, and particularly Lubavitch and Chabad in a case that is very important to the entire Chabad community, a case involving the ownership of the library of the previous Rebbe, which I litigated in the Eastern District of New York and on the Court of Appeals for the Second Circuit and prevailed, and for which, wherever I go in the world, I'll have you know, when I agreed to do that case, a very high-ranking Chabad rabbi said to me, Lewin, you'd better watch it. If you lose that case, there's no place in the world that you can go to. And they were right. I won the case, and every place I go where there's a Chabad shliach, I'm welcomed, and they're so happy to see me. But a couple of years later, the Rebbe had decided that he wanted to have large menorahs, as large as halakhically was permissible, 30 amos high, if possible, in central places all over the world, including in cities in the United States. And that started litigation that frankly occupied me and my law firm for years. Young lawyers in our law firm who came to the firm cut their teeth on menorah litigation. They were sent out to different cities where, to our mazel, the American Civil Liberties Union and various groups that were opposed to any merger or any apparent combination of church and state would bring lawsuits to prevent the menorah from going up. One of the leading first lawsuits was one that involved Pittsburgh and rose in the Third Circuit. That case, in which a Chabad menorah that was 18 foot high was put up in front of Pittsburgh City Hall, adjacent to a Christmas tree that was 45 feet high. And the American Civil Liberties Union brought a lawsuit to force Pittsburgh and Allegheny County, which was also had a courthouse nearby where they had a nativity scene, to force them to remove the menorah and the nativity scene. Chabad came into that case belatedly because the lawsuit was brought by the ACLU against Allegheny County, the city of Pittsburgh, and Chabad had to seek leave to come into the case because it was the Chabad menorah that was at issue. And ultimately the judge allowed Chabad in, and that judge, that district judge, ruled in favor of the menorah and the nativity scene. The ACLU took the case up to the Third Circuit, the Court of Appeals, and our luck in these cases was frequently to run into Jewish judges. The Jewish judges were generally opposed to having menorahs in public places because they had a very strong view about the separation of church and state. And Judge Greenberg of the Third Circuit wrote a majority opinion in that case that said it was unconstitutional to have either the nativity scene or the menorah. I had argued that case in the Third Circuit, lost it. We took it up to the Supreme Court of the United States, and that case in the Supreme Court of the United States established the proposition, which the court ruled on by a 6-3 vote, an opinion by Justice Blackmun, that having a menorah next to a Christmas tree in front of a city hall with a sign that said this was a season of lights was not a violation of the Establishment Clause. It took the Supreme Court well beyond the time that they ordinarily sat. If you follow the Supreme Court, you know that the Supreme Court made sure to adjourn this term, as they do every year, before the end of the month of June. In that year, the Supreme Court sat until July 3rd and decided the Menorah case, the Pittsburgh Menorah case, on the 3rd of July. There are only 2 cases left for decision on that day. The Supreme Court of the United States is very unkind to lawyers. It doesn't tell you, if you argue a case, whether they're going to decide it on a particular day. The Supreme Court of Israel is much more humane to lawyers. If you present a case in the Supreme Court of Israel, they will notify the lawyers to please come to court on the day that they're going to decide the case. With the Pittsburgh Menorah case, there was no such invitation, but it was the last day of the term. So it's one of the few cases that I've argued in the Supreme Court in private practice that I was there to actually hear the case decided. I went not knowing how the court was going to decide it, and I heard Justice Blackmun announce the opinion. It's an amazing opinion because it's an opinion written by Justice Blackmun in which he translates the bracha for reciting the bracha on the candles at Hanukkah. When you light the menorah, he gives you one English translation in the text of his opinion, and then he tells you in a footnote there's an alternative translation. It's the only opinion in the Supreme Court that translates a bracha, not even once, but twice, to tell you, as he says in the text, that the blessing is said. It's the blessing is. He even gives you alternative spellings of the word Hanukkah, but he says that the blessing is one such benediction has been translated into English as, "We are blessing God who has sanctified us and commanded us with mitzvot and has told us to light the candles of Hanukkah." And there's a footnote that says, another translation is, "Praised are you, Lord our God, ruler of the universe, who has sanctified our lives through his commandments, commanding us to kindle the Hanukkah lights." Amen. 2 translations of the bracha in a Supreme Court opinion. This was all Justice Blackmun on his own. He went and had the research done by his law clerks. I will tell you, I wrote the brief in that case. And as I wrote the brief, I thought to myself, I don't want to put too much religion into this brief. The other side is arguing that we are violating the Establishment Clause by making this religious display. I'm not going to put in a lot of stuff about Hanukkah. Well, Justice Blackmun sent out his law clerks to do research and wrote an opinion ultimately about Hanukkah, which Justice Kennedy, in a separate dissenting opinion, said told him too much about the holiday, much more than he wanted to know. But it was July 3rd when I was at the Supreme Court and the court decides the Pittsburgh Menorah case. I'm sitting there in the lawyer's section. Sitting in the row in front of me is the president of the Washington chapter of the ACLU. And we both hear this decision come down, and then the court adjourns. And as we're walking, his name is Arthur Spitzer, as we're walking out of the attorney's section, and he's in a row in front of me. He says to me, "Congratulations, Nat." He says, "You've turned this into a Jewish nation." I thought that was a little bit of an overstatement, but nonetheless, I felt, look, here, I've won this case. It's one of two cases the court has decided today. I better think of something clever to say. There's going to be all these television cameras out in front of the Supreme Court, and they're going to ask me what my feeling is about having won this case. Well, I walk out of the Supreme Court. I walk down the steps. There on the plaza in front, a lot of television cameras. I'm walking through there. Nobody cares about me. Nobody asks me anything. The other case of the two cases that was decided that day was a case that involved abortion rights. That's all the media were interested in. They didn't care about religion when, on the very same day, the Supreme Court was deciding whether or not you had a constitutional right to an abortion. I just walked through this whole gang of television cameras and all that, hailed a cab, and went back to my office. That's the way it goes. Here's my 15 seconds of fame on television. It's gone. But that was the beginning of litigation all over the country over the right to put up a menorah. That very year, Pittsburgh had had a mayor by the name of Richard Caligari, who died while the case was up in the Supreme Court of a disease called amyloidosis. And who was he replaced by? The head of the Pittsburgh City Council, a woman by the name of Sophie Maslow, who was a charter member of the American Jewish Congress Legal Action Committee. Very staunch advocate for separation of church and state. And when Sophie became mayor of Pittsburgh, she announced to the public that she was not going to allow any more of these religious displays in front of City Hall. And the media asked her, "What are you going to do about a Christmas tree?" And she said, "No Christmas tree, no menorah, nothing." Ooh, the media really got after her. No Christmas tree? So finally Sophie said, "Okay, Christmas tree. We'll have a Christmas tree, but no menorah." So amazingly, the year after we win in the Supreme Court the right to put up a menorah, the city of Pittsburgh turns around and rather than being for our putting up a menorah, is against our putting up a menorah. And the following Hanukkah, the week, Monday, Hanukkah that year was Friday evening. Monday morning, I was in federal district court in Pittsburgh to present the argument as to why we had a right to put the menorah up, no matter what the city of Pittsburgh and Sophie thought. And we presented our free speech argument. Now the case had turned from religion and establishment clause to whether we had a free speech right to put up a menorah in front of Pittsburgh City Hall. And we presented a full day to establish that this was a public forum and we had a right to put the menorah up there. At the end of the day, the district judge says, "I'm going to have to think about this overnight. Come back tomorrow." We come back Tuesday. Again, that Friday night is going to be Hanukkah. We come back Tuesday morning, and he tells us, "I agree with Chabad. They have a right to put up the menorah. Just as they did last year, they'll put the menorah up this year." Great victory. I've got to go off to some other case in Los Angeles. And I fly off to Los Angeles Tuesday afternoon, only to arrive and be told that the mayor of Pittsburgh, Sophie Maslow, is going to take this case to the Court of Appeals for the Third Circuit. She's not going to allow a menorah to go up over her objection. And I'm told a couple of hours later, she's gotten a judge to sign a stay of the district court's order that permitted the menorah to go up. I'm in Los Angeles. I have an associate in Washington, D.C., not Jewish, who's working with me on this case. And we decide we're going to try to get the full Court of Appeals in Philadelphia, the Third Circuit, to reverse this district judge's stay. And we send in a written application to the Court of Appeals to reverse that. Don't hear anything on Wednesday after we send it in. Don't hear anything on Thursday. I'm finished with my business in California by Thursday night, and I take the red eye back. We call up the Court of Appeals in Philadelphia to say, I'm ready to fly to Philadelphia to argue in order to be able to put up the menorah in time for Hanukkah Friday night. No word from the Court of Appeals. On the red eye, coming back from Los Angeles to Washington, the plane that leaves Los Angeles at 11 o'clock at night and arrives in Washington at 5 in the morning. Can't sleep. So I write an application to Justice Brennan, who happens to be the justice for the Third Circuit, William J. Brennan. Now you have to understand, Justice Brennan ruled against us back in July on the Establishment Clause issue. But now it's a free speech issue. Do we have the right to put up the menorah in a public forum? I call my secretary. In those days, there was one telephone on the plane. You asked the stewardess, can you please give me the phone? And she gave you the phone and you called, and that was it. So I asked her, I called my secretary, I said, good news, come in at 5 in the morning and type up an application to the Supreme Court. Well, she came in, we typed it up, filed it with the Supreme Court Friday morning. Sophie Masloff files an opposition. The clerk of the Supreme Court calls me up and says, oh, I see from your application that you've applied to the Court of Appeals in Philadelphia and have not heard back from them. I say, that's right. He says, Justice Brennan doesn't like that. He doesn't want to rule while the application is pending before the Court of Appeals. I say, that's not a problem. We'll send a letter to the Court of Appeals. Fax a letter to them saying we withdraw the application because we're before Justice Brennan. Send off that letter, get a call from the clerk who says Justice Brennan doesn't like that. He wants the Third Circuit to rule on your application. Send another letter to the clerk of the Third Circuit. We reinstate it. Justice Brennan is waiting for your ruling. Judges of the Court of Appeals, I have to go home. My non-Jewish associate is staying in the office, but it's Friday afternoon. I have to light Hanukkah candles at home. It's Shabbos at home. I have to go home. I go home. I get a call from my associate who tells me the Third Circuit has decided against us. They refuse to vacate the stay. I said, call up the clerk of the Supreme Court. Tell them that. They called up the clerk of the Supreme Court, and believe it or not, an hour before Shabbos, that Friday, Justice Brennan signs an order that says that the menorah can go up. Sophie didn't take that lying down. She applied to the full Supreme Court to try to get Justice Brennan overruled, and the result the following week was an order from the Supreme Court, 6-3, upholding Justice Brennan. The 3 who dissented were justices who voted with us the first time that the case was up in the Supreme Court. That was the background for the situation in, of all places, Grand Rapids, Michigan. What happens in Grand Rapids, Michigan? The city of Grand Rapids, there's a central place, for those of you who know the city, called Calder Plaza. Calder Plaza had permitted a menorah to go up for 6 years. Nobody objected to it until what happened was the ACLU and the organizations that are staunch opponents of any possible breach of the wall between church and state, the Americans United for Separation of Church and State, bring a lawsuit against the city of Grand Rapids to say you can't put up the menorah. And they come before a district judge, and the district judge, Judge Enslin, in Grand Rapids, agrees with the plaintiffs and says, I enjoin putting up the menorah. Chabad is not even a party in the case. suit by the group against the city of Grand Rapids. The plaintiff rules you can't put up the menorah. And the city of Grand Rapids at that point says, okay, no menorah, that's fine. Chabad, hearing this, says, hey, you forgot about us. We want to get into this case. And, amazingly, December 5th, 1990, 6 days before Hanukkah, Judge Anslin issues her ruling, and on December 13th, 1990, Chabad, which has asked to intervene and asked to vacate that injunction, goes up to the Court of Appeals for the Sixth Circuit, and in a terrific opinion by Judge Danny Boggs, the Court of Appeals for the Sixth Circuit says, Chabad's right. They have a right to put up the menorah all by itself. No Christmas tree, nothing. Just a menorah by itself in the plaza, in Calder Plaza in Grand Rapids. And they have a right to intervene in this case. And, says the Court of Appeals, with one dissent, 2-1, we're going to vacate the order that says that they can't put up the menorah, and the menorah can go up. We were, I will tell you, we were the lawyers for Chabad in that case. We prepared the papers for the Court of Appeals and got intervention in that case. So the menorah was up in Grand Rapids in 1990 and through 1991 under that court order. And finally, the case was argued in the Sixth Circuit and decided in April of 1992 against Chabad by a 3-judge panel, which ruled along the lines of the original district court opinion that you could not put up the menorah. What can you do under those circumstances? Well, what you can do is you can petition for rehearing en banc. And that's what we did. And the result was, I have to tell you, argument I made before the largest court that I have ever appeared before. 15 judges of the Sixth Circuit. 15 judges of the Sixth Circuit, sitting in a semicircle, in bank. I had questions coming from behind me. I was standing at a podium, and there would be questions from judges on this side and on that side. I was given 20 minutes for that argument. The argument ended up being close to an hour with questions, back and forth about the First Amendment, the Establishment Clause consequences, because the argument that was being made by Americans United for Separation of Church and State was that Grand Rapids could not have a menorah in Calder Plaza because it looked like the state was supporting religion. Before the argument, I decided, while I was sitting and waiting, there was another in-bank argument. What do you do while you're waiting in court for another? So I wrote out a limerick that I thought described what my opponent's position was in the case. And after close to an hour of argument up there, Chief Judge Merritt says to me, Mr. Lewin, this is a terrific argument, it's a fascinating case, but your time has long expired, and I think it's time that you sum up. And contrary to what I tell my students at Columbia Law School, when I try to teach about Supreme Court practice, and I say to them, don't try to be funny before a court, because the only people who want jokes before the court and who want to tell jokes before the court are the judges. They don't appreciate the lawyers being funny. But I figured, okay, with that introduction, I can violate the rule. And I thought to myself, when the panel, that 3-judge panel, had ruled against us, there was a dissent written by Judge Danny Boggs. And in that dissent, Judge Boggs even did an attempt at humorous rhyme. So I figured, okay, I'll recite the limerick, and I'll hope that maybe the court, if it rules for us, will copy or put my limerick into Fed second. Well, I recited the limerick. The court laughed. Ultimately, Judge Boggs wrote the majority opinion for 9 judges of the Sixth Circuit in our favor, but no limerick. The limerick was not there. Very disappointing. I'll tell you, and I'll come back to Grand Rapids in a minute, but that a couple of years later, a Menorah case came up in the 11th Circuit in Atlanta, where the issue was whether Chabad can require the city of Atlanta to put up a menorah. Atlanta did not want to have a menorah on the state capitol grounds. There had been one. The ACLU looked up the regulations. They said you can't have any freestanding displays on the grounds of the capitol. We looked at the regulations. We said, you're right. That's what the regulations say. But we said, the regulations don't prohibit having a menorah in the rotunda of the state capitol. And they said, you're crazy. You can't have it out on the grounds. You certainly can't have it in the rotunda. We said, the regulations don't say that. So we brought a lawsuit to force the city of Atlanta to allow a menorah to go up in the rotunda of the state capitol in Atlanta. We lost that in the district court. We lost it before a panel of judges of the 11th Circuit. We petitioned for rehearing in bank. We had rehearing in bank before 11 judges of the 11th Circuit. I argued that case. The argument went fabulously well. The court seemed to be agreeing with us totally. As a matter of fact, we ended up winning that case 11-0. And at some point close to the end of that argument, I decided, look, I'm not going to give up on my limerick. So I recited the limerick to the 11th Circuit. You look at 5 Fed 3rd, page 1394, and this is a distinction that Chaim didn't talk about, but I find one of my great distinctions in the practice of law. There's not many lawyers whose limericks appear in the Federal Reporter. My limerick appears in the Federal Reporter. Judge Teachin, Chief Judge Teachin of the 11th Circuit, said in the opinion, with notable panache, that's not a Yiddish phrase, with notable panache, Chabad's counsel offered the following limerick at oral argument to emphasize his point. This is a limerick that summarizes what my opponents say. It seemed to a young rabbi of Chabad that the Constitution is exceedingly odd to protect all speech in a public place on AIDS or abortion or race, but to prohibit anyone from mentioning God. So that was the limerick that, again, the 11th Circuit put into its opinion. But in the meantime, with regard to the city of Grand Rapids and the Sixth Circuit, the Grand Rapids case and the menorah in Grand Rapids was decided by that 15-judge panel. I had hoped that the Americans United would try to take that case to the Supreme Court, but they never did. I thought it would be a good idea if we could get to the court on that. But in the meantime, Cincinnati took over, and the Sixth Circuit kept at work. Because in Cincinnati, Chabad had asked to put up the menorah in 1987, denied. 1988, denied. 1989, denied. Finally, they brought a lawsuit. The city of Cincinnati said, as these others were saying, we cannot put up a religious display. We cannot allow a private party to put up a religious display in Fountain Square, which is in the center of Cincinnati. We drew a Jewish district judge, believe it or not. And a Jewish district judge, ordinarily the Jewish judges ruled against us in this case, Judge Carl Rubin, district judge in Cincinnati, ruled for us. The Court of Appeals was faced with a request to stay that order that allowed a menorah to go up. They said, Judge Boggs writing the opinion, no, we are not going to set aside Judge Rubin's order. Cincinnati provided several other opportunities to litigate because Cincinnati didn't give up. First, they said we can't put up a religious display. Then, the city fathers in Cincinnati came up with a new idea. What was that? They said that they will not allow a display to be put up in Fountain Square that can be up between 10 p.m. and 6 a.m. That meant that if the menorah went up, and it takes 3 hours to put it up, 3 hours to put it down, take it down, it would have to go down every day. That was litigated in district court in Cincinnati. And Judge Rubin found that that was illegal and struck that down. And the Court of Appeals approved of that. Ultimately, the city of Cincinnati said, we're going to close Fountain Square for 7 weeks, from mid-November until early January. By that time, Judge Rubin was dead. He died in 1995. This happened in 2002. The district judge said, that's illegal. That's a violation of the First Amendment. When the case was appealed to the Court of Appeals, the Sixth Circuit agreed that it was illegal as a violation of the Equal Protection Clause. Cincinnati seemed to be quiet, and the menorah was up there in Cincinnati until 2002, when they again tried to prevent the menorah from going up with some ridiculous regulation. A different district judge found that illegal. The case was going to go up to the Court of Appeals, and the Court of Appeals, while the case was going up on appeal, stayed the order of the district judge so that the menorah could not go up. I remember in 2002 sitting in my office on Thanksgiving Day. Hanukkah was going to start on Friday, the day after Thanksgiving that year. Earliest time, it's just, I think this past year it sort of started, or the year before it started that early, also around Thanksgiving. Just as in the case of Justice Brennan, I applied at that point to the Circuit Justice for the Sixth Circuit. That was Judge Stevens. I wrote an application to Judge Stevens, which was submitted on the Friday morning with Hanukkah beginning Friday evening. Justice Stevens, Friday afternoon, a couple of hours before Hanukkah, Justice Stevens, who had really voted against us in the Pittsburgh Menorah case, and who was, by and large, a very staunch supporter of separation of church and state, issued an order in December of 2002, which allowed the menorah to go up. A repeat of what Justice Brennan had done in the year after we won our case in the Supreme Court of the United States. So that's the history in this circuit of the menorah litigation. Miraculous decisions by Supreme Court justices who saw, even the Supreme Court justices most liberal, Justice Brennan, Justice Stevens, who supported the menorah going up and being displayed in public on constitutional grounds. I think it's an extraordinary history. I was privileged really to be part of that. The opposition within the Jewish community to the menorahs on public places was really extraordinary. My good friend Alan Dershowitz and I had public debates over this issue of whether a religious display like a menorah could go up in public. The divisions within the Jewish community over that issue were very substantial. And unfortunately, Chabad had to overcome opposition from Jewish groups, including the American Jewish Congress and the American Jewish Committee, in these menorah cases. To some extent, that reminded me, and I've given you some legal history here, but I've got to give you some Torah, too. You heard in the introduction about my grandfather, the Reish Rav, who had a very original view of different Talmudic and other subjects. We just read Parshas Balak, and Bilam, the prophet, the non-Jewish prophet, almost begins his praise of the Jewish people by saying, Mi mona afar Yaakov umispar es rova Yisrael. He starts off by saying, who can count dust of Jacob? Dust, afar Yaakov. Very strange metaphor. But the fact is that Abraham was told that the Jewish people are V'samti esaracha ka'afar haaretz. Abraham was told that his descendants would be like dust of the earth. He was also told, V'harba arbe esaracha k'kofvei hashamayim v'kachol hayam. He was also told, your people will be plentiful like the stars of the heavens or like the sand of the sea. Kachol asher al sfas hayam. He was also told, or he said, Ato marta heitei veitivimach v'samti esaracha k'kol hayam. So the metaphors that were used with regard to the Jewish people are the dust of the earth, the stars of the sky, the sand on the beach. And the question is, A, what is the difference between all these metaphors? And B, why does Bilam choose the dust of the earth? So my grandfather explained that the difference between these three metaphors is the difference between the strength of Jewish people at different times. What happens with dust? Everybody knows, every housekeeper knows, dust gathers together. It sticks together in clumps. You've got to wipe it away. It's a clump of dust. The sand of the sea, each particle of sand is separate. When the sea comes over it, it combines the particles of sand. The stars of the sky are separate, and they never come together. He said that's the difference between different times of the Jewish people. There are times when they're naturally together. There are times when they're separate, but something like the water coming over them combines them. And there's times when they're totally separate, like the stars of the sky. And I think that that's the reason that Bilam picked to glorify and to say that the Jewish people were great, because when are they the greatest? When they stick together, like the dust of the earth. At other times, when it takes something like water to make them combine, or when they separate. Like too often the Jewish people are separated today and disagree today. That's when the Jewish people are weakest. But Bilam said they're strongest when they are like Afar, when they are like the dust of the earth. I leave you with that message.